Hi Rob, thank you for joining us today. As you're aware, the Guernsey Disability Alliance, the GDA, has been running a series of workshops about disability discrimination legislation. And as part of that, we've run 2 sessions, an introduction to the legislation, but also a more involved session. During that session, we thought it'd be really useful to hear from somebody that's been sort of heavily involved in researching and look what we're going to cover today.
Yes, indeed. Well, my name is Rob Platts, and I'm the founder and now a quality advisor to the Guernsey Disability Alliance. I got involved with looking at legislation when we realised that there's an opportunity to look at bringing in disability discrimination legislation. We needed to go away and do some research. We felt that it was wrong just to accept perhaps what the UK legislation was all about. We didn't want to just import that model without seeing whether there was something perhaps better elsewhere. So I went off and for about 2 years looked at the various models available all around the world. So I have to stress I'm not legally trained, but I suppose I have what I would call a good understanding about what's out there in the rest of the world, and perhaps some understanding of what doesn't work very well and what might work better.
Great, that's really useful, thank you. So yes, we've covered such subjects as why do countries have the legislation, who is protected, but we're talking at the moment in sort of April 2016. Can you just tell us where we're at the moment in Guernsey within the Channel Islands?
Well, we are, I would say, 90% there. We have the basis for what our legislation might include, but the proposed legislation has yet to go out to consultation, and there are some other details, some finer details which need to be sorted out yet.
Great.
So nothing is finalised. I have to be absolutely clear about that.
Great. So today we're talking sort of more concepts and yes, possible things that could be included, just to try and give us an overview on the topic and a greater understanding of disability discrimination legislation.
Absolutely right.
Brilliant. Thank you.
There are a number of important reasons why we need legislation protecting against discrimination by reason of disability. There is a wealth of research, including Guernsey State's own 2012 survey, which shows that disabled people experience undue disadvantage in many walks of life. Legislation is needed to try to prevent discrimination happening in the first place, but is also needed to correct instances of discrimination that have happened. And then we hope the legislation will prevent them happening again, and it will also compensate people who have suffered loss through such discrimination. You will note that I've used the term unjust disadvantage, as it's important to realise that not all discrimination is wrong or reasonably avoidable. For example, many of Guernsey's older buildings are unlikely ever to become fully accessible to wheelchair users, as it would be impractical or too costly to make the changes needed. Our legislation will recognise these limitations. Legislation is a vital part of the process of breaking down unreasonable barriers which prevent people with disabilities from achieving equality of opportunity. One important reason for introducing legislation is that it provides impetus for awareness raising and attitude change. It'll have an effect a bit like the seatbelt law had. Most people knew wearing a seatbelt made sense, but many just didn't comply until the law was introduced. The very fact the law came in meant people started to discuss and understand the safety issues. Whilst the main reason Guernsey is introducing legislation is to try to prevent discrimination from happening in the first place, the legislation will also provide opportunities, through a process of mediation, for complaints of discrimination to be resolved. Should that mediation fail, the final step would be for complaints to be considered either by a tribunal or court. People who have suffered loss or injury through discrimination will be able to claim compensation through the tribunal and court system. There are other reasons too for introducing discrimination legislation. For example, the United Nations Convention on the Rights of Persons with Disabilities explains that such legislation is a vital part of protecting the rights of disabled people. In order to comply with the Convention, governments must introduce legislation. The states have already resolved to comply with the Convention and protect disabled people's right to seek and remain in employment, and not to be unjustly disadvantaged whilst in employment by reason of their disability. It will also recognise disabled people's right to be able to access and enjoy goods and services on an equal basis with others, so that we can carry out daily activities like going shopping, using transport systems, accessing information and taking part in social and sporting activities without undue disadvantage. This access to services includes access to education, all forms of education. Education is seen as so fundamentally important to life chances that our legislation will deal with education separately to other services. And so, to summarise, Guernsey's disability discrimination legislation will have effect in the fields of employment, access to goods and services, and in education. The undue disadvantage I mentioned earlier, or treated differently, simply because they are disabled. This form of discrimination usually results from prejudicial attitudes and is known as direct discrimination. Just as some people hold prejudicial attitudes about race or gender or religion, some people hold prejudicial views about disabled people. Prejudicial and can spread within social and family groupings, especially if people with the characteristic in question are not represented within the group or if they are in a minority. Under the new legislation, there will be no objective defence to an accusation of direct discrimination. The only defence available is for an employer or a service provider to prove that the offence did not happen. It's worth noting that the UK law requires that the person bringing a complaint of direct discrimination may be required to show how the way they've been treated differs from the way a person who isn't disabled would be treated. This person is not yet clear whether Guernsey's legislation will include this added complication of needing to identify a comparator. When someone directly discriminates, they are knowingly treating somebody differently. But sometimes people discriminate without realising they're doing it. This can happen when an employer or service provider applies a general policy, practice or criterion which disadvantages a disabled employee or customer more than it disadvantages somebody who doesn't have that disability. This is known as indirect discrimination. For example, a restaurant owner who bans all dogs from the restaurant would make it more difficult for a person who relies on assistance or guide dog to use that restaurant. In UK law, this could also be an offence called discrimination arising from disability, because the restaurant owner isn't discriminating against the disabled person because of their disability, but the disabled person nevertheless experiences disadvantage from something connected with their disability. If challenged, and the restaurant owner refuses to make an adjustment to this policy, the restaurant owner might face a further complaint of having committed a separate offence known as failure to make a reasonable adjustment. We'll deal with reasonable adjustments in a little more detail later. While there is no objective defence for direct discrimination, employers and service providers will be able to defend both indirect discrimination and discrimination arising from disability by providing objective reasons to explain why this practice, policy or criterion was reasonably required. We will discuss objective defence in further detail later too. Other forms of disadvantage include victimisation and harassment. Harassment is systematic and/or continual unwanted, annoying or offensive actions, and these can include threats and demands. Victimisation is action by an employer or service provider in retaliation for bringing us or supporting a complaint of discrimination. For example, if a pub landlord directly discriminates against a person with learning difficulties, saying, "I'm not having his sort in my pub," and then a friend of the person with learning difficulties was also barred for trying to stop the landlord from discriminating in this way, then the friend will have suffered victimisation. So, to summarise, the offences in our disability discrimination legislation are likely to include direct discrimination, indirect discrimination, failure to make a reasonable adjustment, and harassment and victimisation. A further offence of discrimination arising from disability may also be included, but this has yet to be confirmed. It is likely that the legislation will allow for the development of further or other ancillary regulations, governing things such as accessibility standards of public transport, and perhaps even regulations concerning the requirement to allow disabled people to be accompanied by and to use assistive technology and animals. People who experience disadvantage because of a physical or mental condition or impairment will be protected. People will also be protected on the basis of a perceived impairment or condition. For example, someone who is believed or impugned to have HIV/AIDS, but does not in fact have that disease, will be protected. In addition, people who are associated with a disabled person, and in particular carers of disabled people, will be protected from disadvantage arising from their connection with that disabled person. Everyone will be protected from victimisation in connection with discrimination by reason of disability. Disabled people do not have to have had a condition for any particular length of time, nor is there a judgment to be made as to how severely the condition affects a person's ability to perform day-to-day activities. Guernsey's legislation is likely to concentrate initially on the reason for and effect of the alleged discrimination, and it will consider in particular how the alleged discrimination has affected a person's ability to participate, rather than the effect of the impairment or condition on personal functionality. This has yet to be finalised. The UK and USA, two of the earliest jurisdictions to introduce disability discrimination legislation, are unusual in operating a list of both included and excluded conditions, and actually both jurisdictions' lists are different. These lists were introduced initially to calm fears that protection might be given too widely and open a floodgate of complaints. There is evidence that these lists, and indeed the restrictive definitions of disability operated by the UK and USA, have made the legislation more complex and less effective than originally hoped. Why they have discriminated against an employee or customer. The process of deciding who is and who isn't to be protected is far more complex under UK law than it is likely to be under Guernsey legislation. Disability discrimination legislation around the world, and it is probably the single most effective legislative measure helping disabled people gain and remain in exercising its functions in relation to the school, to secure that if any registered pupil has a special education need, then the special education provision that is required for him or her is made. Information and guidance will be available which will explain how employers and service providers should carry out assessments and how to judge whether it is reasonable to make an adjustment. It is likely that the judgment of reasonableness will take account of things such as how effective an adjustment is likely to be, the financial and other costs of making the adjustment. It has to take into account safety and indeed the practicality of the step, including the interchangeability of workforce and of other facilities. It should also take account of the extent of any disruption caused, including disruption of a collective agreement or disruption of services to the public. It can take account of the extent of the organisation's finance or other resources, and that's an. And we should the assessment of reasonableness should also take account of the availability to the organisation of financial or other assistance to help make an adjustment. There are grants available, for instance, from certain places. And in general, the type and size of the organisation will be taken into account. It is possible also to take the morale of employees into consideration, so long as that morale is not based on prejudice. And finally, the extent the adjustment would interfere with the operation of the organisation's business in general. Well, these arrangements have not been finalised. It was hoped that this information might be available from an equality and rights organisation, but the business case for such an organisation, required by a state's resolution, has not yet been completed. This detail has yet to be finalised too. However, it is likely that the existing Employment and Discrimination Tribunal will deal with all employment-related complaints. The same tribunal is also likely to deal with complaints involving access to goods and services and education, so long as any claim for compensation does not exceed a certain amount, and that's possibly around £10,000. Complaints relating to goods and services and education where compensation sought is greater than the tribunal's award limit are likely to be heard by the Royal Court. Again, this detail is yet to be agreed, but as with all such legislation, sufficient time will be allowed in order to review and amend policies and procedures, and so that I mentioned earlier that suppliers and employers will be able to objectively defend a complaint of indirect discrimination or discrimination arising from disability. For example, in the case of the restaurant owner and the person with a guide dog we talked about earlier, the restaurant owner might argue that the dog rule was applied on the basis of hygiene, and that in addition some dogs bark and might cause distress to other customers. In this case, the restaurant owner is likely to fail because a tribunal or court is likely to conclude that guide dogs are highly trained and that the risk of distress to customers and the increased risk to food hygiene is small and outweighed by the disadvantage experienced by the disabled person. In bringing their defence, an employer will need to prove that applying the practice or policy or criteria was a proportionate means of achieving a legitimate aim.